This is Dolor Factor Live. I'm here with Veronica Cenac and also with Andrea St. Rose, and we're talking about the laws of succession. I'm going to go straight to you, Andrea, with another question. What is meant by letters of administration and what is meant by probate?
The probate is really the instrument that is used to deal with the property of the testator upon death, whereas the letters of administration is the instrument that would be used if the individual dies intestate, in which case the law steps in.
Okay.
So this is basically the difference.
Also, another question for you, Andrea. If my father had a joint account with one of his children who was his caretaker and the father died, is that child entitled to all the money left in the will?
Yeah,
Sorry, in the account. Is that child entitled to all the money left in the account?
Yeah. I heard of a decision with respect to whether or not someone was joined to an account as a mere convenience for getting the monies out of the account. But to the best of my knowledge, if it's a joint account, it means that the person can take wholly, because it's joint, especially if it says and.
And as lawyers, typically we disagree. I think it has, you have to go to the intention or when the account was set up and look at how it was set up. Whether it was and the two people together or and or would make a difference. Because if it is or, it means that that person was also entitled to almost any of the money in the account. But if it's and, it means that both had to be there. So no, it falls part of the estate of the person who is the principal account holder. That becomes that person's estate. But then we can
Yeah, but I was thinking of the situation where it says and or. That's what I was
in
thinking.
and or, yes.
Yes,
I would agree with you.
Yeah.
Okay, this is my last question for tonight, and don't worry, people, if you have sent us questions, we may not be able to answer them tonight. Well, we won't be able to answer them tonight live, but I will send the questions to Veronica and to Andrea, and when they respond, we'll put them on the Dolor Factor Live website for you. The last question to you, Veronica. What if a man is living with a woman for 30 years, not married, but sharing a home, and that man has a child with another woman? Is that child entitled to get a share if the man passes?
Well, if that man passes, never been married, so he qualifies for the definition of a single man under the law, and he has recognized the child as a child of his. Either his name is on the birth certificate, he's treated him as such, there is a maintenance order against him, there are provisions that it determines how the law recognizes as a child of the man, then the child takes even above the common law spouse. So that common law spouse would generally not be entitled to anything. Nothing whatsoever. The child would be the one who's entitled in that case.
Okay. Well, you know, I hope that everyone is listening to this, because it's not just the person who is making the will, but the people who are looking after the people, perhaps, who you are expecting or hoping that they will help you if they pass away. So all these things, you need to start thinking, people. One last question I want to throw to both of you very briefly. As a lawyer, what's frustrating to you when it comes to dealing with wills? What would you say, Andrea? What's frustrating to you when you have to deal with wills? Or the lack of it, whichever one you prefer to answer.
The hesitation that sometimes, you know, goes into the person trying to determine what their wish is, huh? And even when you try to give them directions and they do not, you know, consider the direction that you were giving, that can be a bit frustrating, because then at the end of the day, when it comes to execute that particular document, problems will arise.
I think for me, it's the idea that people believe that somehow their family get along and everybody will be able to know who's supposed to get what. Everybody's supposed to know what their intentions are. You can state your intentions verbally over and over and over again. At the end of the day, if you do not have a will, the law steps in, and there are people who you would want to get certain things who would not by law be entitled to it. And the law takes effect, and then everybody who would never took care of you or anything that comes in and says, well, that is the law, and they will just
let me be very clear about this, because I think there are a lot of people who are in situations where they have happy families, everybody's fine, so mom or dad, they do not make a will because everything is fine. When, let's say, mom or dad passes away, you're saying if there is no will, the law will say what?
Yeah, the law steps in.
Yes, the law says who gets what.
And so the siblings don't get a say. So it means that even if everyone is happy, mom, dad, whoever it is, you need to make that will to make sure that your children get what they want. It's not a matter of you don't trust your children, because maybe people may be thinking that I don't want my children to think that we don't trust them. It's not about that. It's about ensuring that your children get what you wanted them to get. And don't forget, it's not just about money or land, because you may not have money, you may not have land, but you may have certain things that you know that you want. And my parents and I, we've spoken. My mother tells me about a tea set that I bought for her when I was a teenager. She says, D, that's yours, that's yours. Everybody knows that, but maybe the government may say, well, no, Dealey's not going to get the tea set, and you know, nothing that mom or dad can do, or my brothers and sisters will do. So please be very, very careful. Write a will, and if you already have one, revisit, because another thing is perhaps you have a will that you included someone who has since passed away.
Yeah.
And if they have passed away, then that share is going to go somewhere else. Maybe there is someone else now in your life who deserves that share. So please revisit that. It's time for us to say goodbye. But before we do that, very quickly, let us pick our winners for tonight. So I don't know who has the Organica bag. I think you have it, Andrea.
I have the Organica
Okay,
bag.
to what we asked, for you to win an Organica or organic millet rice cereal fruit juice and a packet of stone ground whole wheat flour, you needed to say how long Organica has been open. The answer is 3 years. And the winner?
G. Augustine.
G. Augustine. Okay, so you've won something nice and organic. And what Veronica has, all you had to do was tell us your favorite Farron's ice cream flavor. And what do you have?
I think this says vanilla.
Vanilla ice cream,
Vanilla
okay.
ice cream.
And the person's name?
There's no name, but there is a number.
Okay.
And the last bit of it is 370.
All right, so if you said 370, you're going to get your favorite Farron's ice cream. So the time has gone by really quickly. Old school friend, it's really lovely to see you after all these years, and I'm sure we will keep in touch. I hope that we do. So Andrea St. Rose, thank you so much. And can you please give our viewers your contact details, please?
Yes, I could be reached at centralg@yahoo.com or at telephone number 716-6993.
So thank you very much. And Veronica, again, a pleasure to be on set with you. And any final words and your contact details, please?
Just to encourage everybody to ensure that you have your estate and these kind of matters in order. Firstly, do a will. It's really important. And you can reach me. Now, I think we should say that any advice we give coming out of the show, initial questions we have to answer it free, because we cannot be charged, because it goes against our ethical principles as lawyers to be, as you say, touting.
Right.
So the questions you ask, we will answer them free of cost.
Okay.
Coming from the show. And my contact details are telephone number 458-4763, and my Gmail account, very simple, vcenac@gmail.com.
Thank you very much, ladies. And also, viewers, if you didn't have an opportunity to take those contact details down, if you visit the dolorfactorlive.com website, we will be posting that information up for you tomorrow, and you have our contact numbers. If you email us or call us, we'll give you the information there. Again, thank you so much to my guest tonight. Don't forget, if you'd like to be the person who puts their name to UFactor's logo and theme, or if you'd like us to visit your children's school for phase 1 of UFactor, send us an email. And also you can visit dolorfactorlive.com. Don't forget the press club with Clinton Reynolds immediately following the news this Saturday. Next week on DFL, we have a very special visitor, and you have to actually come to the website Dolor Factor Live to find out who that's going to be. My last words for you tonight: stop procrastinating. If you really love those around you, prepare for them by producing a will that is updated when necessary. Leaving a will isn't always about money. You may have prized possessions, jewelry, namesakes that you want a particular person to have. A will is the only way to ensure your wish is carried out. Don't assume you know the laws of succession. Clarify now so that you can produce a will that you are happy with. Why? Why should you? Because DFL asked you to. Thank you for watching Dolor Factor Live. On behalf of the DFL team and DBS, good night and God bless.